Hello everyone, I'm Anu, an engineer and a law graduate, and welcome to my channel where law meets logic and learning becomes easy. Welcome back to part 3 of our Family Law 1 Hindu Law series. In this video, we'll be diving deeper into two powerful legal tools that play a crucial role in protecting our environment in India. What is adoption under Hindu law? Explain the requirements and legal effects under the Hindu Adoption and Maintenance Act, 1956. Define maintenance under Hindu law. Discuss its nature and extent under Old and Modern Hindu law. What is the Hindu Succession Act, 1956? Explain its scope, main features, and the general rules of succession for male and female Hindus dying intestate. Whether you're preparing for exams or just eager to understand how the law empowers citizens and authorities to fight pollution and safeguard nature, you're in the right place. Let's continue where we left off. Question 6. What is adoption? What are the requirements of adoption under the Hindu Adoption and Maintenance Act, 1956? Who is capable of giving a child in adoption? What are the legal effects of adoption? Introduction. Adoption is a legal process by which a person assumes the parenting of a child who is not biologically their own. Under Hindu law, adoption is not merely a social or emotional decision. It has religious and legal implications. In ancient times, adoption was primarily performed to ensure the continuity of the family line and to perform religious rites. The Hindu Adoption and Maintenance Act, 1956, HAMA, codified and modernized the law of adoption among Hindus. This answer covers the meaning and object of adoption, the legal requirements for a valid adoption, who can give a child in adoption, the legal effects of a valid adoption, relevant case laws. 1. Meaning and object of adoption. Adoption under Hindu law means the legal transfer of a child from the biological family to the adoptive family. It creates a permanent parent-child relationship between persons who are not naturally related. The child ceases to be a part of the natural family and becomes a full member of the adoptive family with all legal rights. Objects of adoption. To ensure the performance of spiritual and religious duties, particularly the offering of pindan to ancestors. To provide emotional and social support to the childless. To secure the inheritance of property and family lineage. To provide a home and future for orphaned or abandoned children. 2. Requirements of a valid adoption under HAMA 1956. Section 6 of the Hindu Adoption and Maintenance Act lays down the essential conditions for a valid adoption. An adoption is valid only if the following conditions are fulfilled. A. Capacity of the adoptive parents. The person adopting must have the legal capacity and right to adopt. A male Hindu can adopt if he is of sound mind and not a minor. If he is married, he must take the consent of his wife unless she is of unsound mind or has renounced the world. A female Hindu can adopt only if she is unmarried, a widow, divorced, or if her husband is dead, of unsound mind, or renounced the world. A married woman cannot adopt independently during her husband's lifetime. Case law, Gisalal vs. Dapubai, 2011. The Supreme Court held that a woman cannot adopt during her husband's lifetime unless he is legally disqualified. B. Capacity of the person giving in adoption. Only certain persons can lawfully give a child in adoption. The father, with the mother's consent. The mother, if the father is dead or disqualified. The guardian, with the court's permission under Section 9(4). The consent of both parents is ideal, but in certain cases, the Act permits one parent to act alone. C. The person adopted must be eligible. Section 10 of the Act lays down the qualifications for a child to be adopted. Must be a Hindu by religion. Must be unmarried except if there is a custom that allows married adoption. Must be under 15 years of age unless a custom allows otherwise. Must not have been already adopted. Case law, Lakshman Singh Kothari vs. Smith Rup Kanwar, 1961. The court emphasized the importance of meeting statutory conditions for adoption. Other essential conditions, Section 11. If a male child is adopted, the adoptive parents must not already have a living male child in the same line. If a female child is adopted, the adoptive parents must not already have a living female child in the same line. The child must be actually given and taken in adoption with the intention to transfer the child permanently. This giving and taking is the most crucial ritual, signifying the intention to adopt. 3. Who can give a child in adoption? Only specific persons are legally authorized to give a child in adoption, as per Section 9 of Hama. A. Father. The father can give a child in adoption with the consent of the mother, unless the mother is deceased, insane, or has renounced the world. B. Mother. The mother can give a child in adoption if the father is dead or legally disqualified. C. Guardian. A guardian can give a child in adoption only with the prior permission of the court. The court will consider the welfare of the child before granting permission. This provision ensures that children without natural parents are also eligible to be adopted legally and fairly. For legal effects of adoption, adoption has far reaching consequences. Once the adoption is completed legally, the child is considered the biological child of the adoptive parents. A. Termination of relationship with natural family. The adopted child ceases to have any relationship with the natural parents. This includes loss of rights to inheritance or obligations in the natural family. B. Creation of relationship with adoptive family. The adopted child is considered the legal child of the adoptive parents. Gains all rights of inheritance, can use the family surname, becomes liable to maintain the adoptive parents, has the same legal status as a biological child. Example: if a child is adopted by a couple, he can inherit their property just like a natural born child. See, adoption is irrevocable. Once made, a valid adoption cannot be cancelled, nor can the child return to the natural family. Even by mutual agreement, the adoption cannot be reversed. Case law: Valluri Tirumala vs. Valluri Venkateswara, 1979. Adoption, once validly made, cannot be undone even if the adoptive parents regret the decision later. 5. Other considerations. A. Customary adoption. In certain cases, customary laws may permit practices like adoption of married individuals or those above 15 years of age. These customs must be ancient, certain, and reasonable. B. Registration. While the Act does not require mandatory registration of an adoption, it is advised to document the adoption formally to avoid legal complications in the future. Conclusion: adoption under Hindu law serves not only a social purpose but also a legal and spiritual one. The Hindu Adoption and Maintenance Act 1956 ensures that adoption is conducted in a transparent, regulated, and fair manner. It lays down clear rules on who can adopt, who can be adopted, and what the consequences are. Understanding these provisions is crucial for anyone considering adoption or working in the field of family law. Question 7. Define maintenance. Discuss the nature and extent of maintenance under Old and Modern Hindu law. Introduction. Maintenance refers to the financial support that one individual is legally obligated to provide to another. In Hindu law, the concept of maintenance is deeply rooted in moral, social, and legal responsibilities. Traditionally, maintenance was seen as a duty of the head of the family to provide for all dependents. With time and legal reforms, particularly through the Hindu Adoption and Maintenance Act 1956, maintenance has become a structured right backed by statutory law. This answer will explore the definition and purpose of maintenance, the concept of maintenance under ancient Hindu law, statutory provisions under modern Hindu law, who is entitled to maintenance, the extent of maintenance, relevant case laws. 1. Meaning and purpose of maintenance. Maintenance includes provision for food, clothing, shelter, education, and medical treatment. It is a legal duty imposed by law to ensure that individuals who are unable to support themselves are not left destitute. In a Hindu family context, it primarily refers to the duty of a husband to maintain his wife, a father to maintain his children, a son to maintain his aged parents, a person to maintain other dependents, such as widowed daughters in law or unmarried daughters. Objective of maintenance: ensure social justice and protection to weaker sections like women and children. Maintain family integrity by obligating the breadwinner to support dependents. Prevent destitution and ensure a basic standard of living. 2. Maintenance under ancient Hindu law. In ancient times, Hindu law was derived mainly from smritis, dharmashastras, and commentaries by scholars like Manu, Yajnavalkya, and Narada. Maintenance was not merely a legal obligation, but a religious and moral duty. Key features: a son was duty bound to maintain his aged parents, a husband had to maintain his wife during marriage and even after separation, unless she was at fault. A widow was entitled to maintenance from her husband's family. Daughters were not traditionally entitled to maintenance after marriage but were before marriage. In ancient Hindu law, there was no strict enforcement mechanism. The obligation was mainly moral and religious, and disputes were often resolved within the community or family elders. 3. Maintenance under modern Hindu law. The codification of Hindu personal law through the Hindu Adoption and Maintenance Act 1956 (HAMA) brought about significant clarity and legal enforceability. Section 3b. Definition. Maintenance includes provision for food, clothing, residence, education, and medical attendance and treatment. In the case of an unmarried daughter, also includes reasonable expenses of marriage. 4. Who is entitled to maintenance under HAMA 1956? A. Wife, Section 18. A Hindu wife is entitled to be maintained by her husband during her lifetime, even if she is living separately, provided the separation is on reasonable grounds, e.g., cruelty, desertion, or if he has remarried. However, she is not entitled to maintenance if she is unchaste. She has ceased to be a Hindu by conversion. Case law. Krishnamurthy v. Syed Begum, 2001. The court held that a wife who was treated with cruelty and left the matrimonial home is entitled to maintenance. B. Children and aged parents. Section 20. A Hindu is bound to maintain his or her legitimate or illegitimate children, his or her aged or infirm parents. This obligation exists only if the dependent is unable to maintain themselves from their own income or property. C. Widowed daughter-in-law, Section 19. The father-in-law is obliged to maintain the widowed daughter-in-law only if she is unable to maintain herself and does not have any property or other support. D. Other dependents, Section 22. The Act also includes other dependents such as minor brothers and unmarried sisters, widowed sisters, widowed stepmothers, paternal grandparents and grandchildren, if no nearer heirs exist. 5. Nature and extent of maintenance, as in nature. Personal right. It is a personal legal right, meaning it cannot be transferred or waived under coercion. Conditional. Maintenance may depend on the conduct of the person claiming it, e.g., unchaste wife or able-bodied adult son may not get it. Enforceable can be claimed through civil or criminal courts under HAMA or Section 125 CRPC. B. Extent. There is no fixed amount prescribed in the Act. The court considers status and income of the person liable to pay, reasonable needs of the person claiming, number of dependents, whether the claimant has property or income, age, health, and educational needs of dependents. Case law. Chaturbhuj v. Sitabai, 2008. Supreme Court held that a wife who is unable to maintain herself is entitled to maintenance even if she is living separately with valid reason. 6. Maintenance under other laws. Apart from HAMA, maintenance can also be claimed under Section 125 of Criminal Procedure Code, CRPC, quick remedy for wife, children, and parents irrespective of religion. Protection of Women from Domestic Violence Act 2005 provides for monetary relief and maintenance. Hindu Marriage Act 1955, Section 24 and 25 provide for maintenance pendente lite during proceedings and permanent alimony after divorce. Vite conclusion. Maintenance under Hindu law has evolved from being a moral obligation to a well-structured legal right. The modern law recognizes the need to protect vulnerable members of the family, wives, children, aged parents, and widows. The Hindu Adoption and Maintenance Act 1956 ensures that these persons can live with dignity and receive necessary support. Courts play a crucial role in ensuring that this support is just and equitable based on individual circumstances. Question 8. Hindu Succession Act 1956, Scope and Main Features. Introduction. The Hindu Succession Act 1956 is one of the key statutes that codified and reformed the Hindu laws of inheritance and succession. Before this act, succession under Hindu law was governed by various schools like Mitakshara and Dayabhaga, leading to inconsistencies and inequalities, particularly with respect to women's rights. The Hindu Succession Act aimed to bring uniformity and clarity, ensuring a just system of inheritance for Hindus. The Act applies to all Hindus, and it governs both testamentary succession through a will and intestate succession when a person dies without a will. It has undergone significant amendments, the most notable being the Hindu Succession Amendment Act 2005, which revolutionized the rights of daughters in co-parcenary property. Scope of the Hindu Succession Act 1956. 1. Applicability. The Act applies to Hindus by religion, including followers of Virashaiva, Lingayat, Brahmo, Prarthana, and Arya Samaj. Buddhists, Jains, and Sikhs are also treated as Hindus for the purpose of this Act. Illegitimate children of Hindu parents, if both parents are Hindu, are also included. Persons converted to Hinduism or reconverted to Hinduism from other religions. Two exceptions. The Act does not apply to Muslims, Christians, Parsis, or Jews. Scheduled tribes governed by customary tribal laws, unless the central government notifies otherwise. Main features of the Hindu Succession Act 1956. 1. Equal treatment of male and female heirs, post 2005 amendment. Originally, the Act granted limited rights to female heirs. However, the 2005 amendment transformed Hindu inheritance law by recognizing daughters as co-parceners by birth at par with sons. Daughters now have equal share in the ancestral property, can demand partition of joint family property, are equally liable for debts of the joint family. Case law, Vinita Sharma versus Rakesh Sharma, 2020. The Supreme Court held that daughters have co-parcenary rights by birth, whether or not the father was alive on the date of the 2005 amendment. Do. Abolition of the doctrine of survivorship for co-parcenary property. Before the 2005 amendment, in a Mitakshara co-parcenary, property passed through survivorship, i.e., it automatically went to surviving co-parceners. This excluded female heirs. Now, the Act abolishes this doctrine and provides succession through inheritance, ensuring daughters inherit equal shares like sons. If a co-parcener dies, his/her share devolves as per succession rules, not survivorship. 3. Class I and Class II heirs. The Act lays out a hierarchical structure of heirs to simplify succession. A. Class I heirs get first priority. Includes son, daughter, widow, mother, son, daughter of a predeceased son or daughter, widow of a predeceased son. They inherit simultaneously and equally. B. Class II heirs, considered only if no Class I heir exists. Includes father, siblings and their children, relatives like uncles and aunts. C. Agnates and cognates. If no heirs from Class I or II are available, agnates related through male lineage are considered first. Cognates related through either male or female come next. Example, if a Hindu male dies intestate leaving a widow and daughter, both are Class I heirs and will inherit equally. 4. Rules for succession among female Hindus. Section 15 of the Act provides a separate scheme for female succession, which is different from that of males. If a female Hindu dies intestate, property inherited from her parents goes to her father's heirs. Property inherited from her husband or in-laws reverts to the husband's heirs. Self-acquired property goes to sons and daughters, including children of any predeceased son or daughter. Husband, heirs of the husband. Heirs of the father, heirs of the mother. Case law, Om Prakash vs. Radhacharan, 2009. Supreme Court ruled that the source of property is relevant in deciding succession in case of a female Hindu. 5. Testamentary succession allowed. A Hindu can also dispose of their property by will. The Act allows full freedom to write a will unless it violates any other law, e.g., laws protecting minors or dependents. However, if a person dies without making a will, the rules of intestate succession under the Act apply. 6. No discrimination based on marital status or legitimacy. The Act recognizes both legitimate and illegitimate children as heirs if both parents are Hindu. Married daughters have the same rights as unmarried daughters. Adopted children are treated as natural-born children in matters of inheritance. Case law, Geeta Hariharan versus Reserve Bank of India, 1999. This case confirmed equal legal standing for mothers as natural guardians, reinforcing gender neutrality in interpretation. 7. Protection against disqualification. Certain disqualifications like conversion, murder of the deceased, etc., can bar a person from inheriting. However, mere conversion from Hinduism does not bar succession unless prohibited under specific customary laws. However, a murderer cannot inherit from the person she has killed based on the principle that no one can benefit from their own wrong. 8. Simplification of Hindu succession law. The Act standardized succession for Hindus across India, reducing regional inconsistencies due to different schools, Mitakshara vs. Dayabhaga, gender discrimination in inheritance, confusion due to uncodified personal laws. 9. Retrospective clarification 2005 amendment. The 2005 amendment was interpreted by courts to be retroactive, not retrospective. A daughter's right as a co-parciner accrues by birth, irrespective of whether her father is alive or not. Case law, Danama vs. Amar, 2018. Daughters born before 2005 but whose father died after 2005 were held entitled to equal rights in co-parcenary property. 10. Property of a Hindu female is her absolute property. After the Hindu Succession Act 1956, Section 14 provides that any property possessed by a female Hindu acquired before or after the commencement of the Act becomes her absolute property. This was a progressive step to abolish the concept of limited estate. Case law, Tulasama vs. Sisha Reddy, 1977. Supreme Court held that a Hindu woman's limited estate would become absolute property under Section 14(1), provided she was in possession of the property. Conclusion. The Hindu Succession Act 1956 was a major step toward codifying and rationalizing the law of inheritance for Hindus in India. It not only brought consistency to the application of succession laws across regions, but also ensured greater gender equality, particularly with the 2005 amendment. With key features like equal rights to daughters, abolition of survivorship, and legal recognition of adopted and illegitimate children, the Act reflects a progressive and inclusive approach to family property rights. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. In the next part, Part 4, we will continue with the remaining important topics. General rules of succession of male and female Hindus dying intestate. What is the Hindu Minority and Guardianship Act 1956? Who is a minor and what are the types and powers of guardians? Discuss the rights, liabilities, and responsibilities of guardians under Hindu law regarding the property and welfare of minors. Please like, share, and subscribe. Thank you for watching.